Um, I want to introduce Phil Lapatin, who
It's not on.
has.
It's not on. You ought to wait a couple of minutes anyway.
How do I turn it on? How about just use this one? Can you hear me better now? Thank you all for joining us this afternoon. I want to introduce Phil Lapatin, who is a member of the real estate department at Holland and Knight, who concentrates on commercial leasing for both landlord and tenant. He has been general counsel, outside counsel to the Greater Boston Real Estate Board since before many of you were born, 1973. He has been doing this now for 36 years. In 2008, he received the Richard B. Johnson Award, a Lifetime Achievement Award for conveyancing. It's my pleasure to introduce him, but I first have to make a few comments. I have to thank Staples Business Advantage for their general sponsorship of these conference rooms and Massachusetts Attorneys Title Group. As far as CLE credits are concerned, we've been approved, or this session has been approved for 4.5 CLE credits in Rhode Island. New Hampshire has changed their CLE system. They now have a self-certification system. You simply sign in here and tell the folks in New Hampshire that you've been here, and there's no checking in on it. With that, I'd like to introduce Phil.
I'm sure I speak for all of you when I say I wish the trains were as punctual as Peter Wittenborg. It's not my job today to introduce Hank Philippi Ryan, but I couldn't help noticing that her two best-selling books are entitled The Other Woman and The Wrong Girl. Now, do you detect a common theme? Even her latest novel is called Truth Be Told, which implies that somebody's lying about where they've been and what they've been up to. I do guess it's only natural that stories about infidelity are so common. After all, it's been suggested that 80% of married people cheat in the United States. The other 20% go to Canada. I've always tried to be a faithful husband, but I'm not always sure that my wife reciprocates. Just recently, she said, "I feel like doing something wild tonight." She handcuffed me to the bed and left the house. Now, along those lines, one requirement of adverse possession, which tends to get overlooked, is that the use of someone else's property must be notorious. Now, we're not talking notorious like Kim Kardashian. All we mean is that it has to be sufficiently obvious so that a landowner exercising reasonable supervision will be made aware that something is amiss. In the Haunt Road, the owner had no reason to suspect that somebody had installed a sewer pipe beneath his property until he became aware of a foul odor in November 2011. The land court refused to recognize a prescriptive easement. Now, when the property in question is woodlands, adverse possession requires that the land be cultivated or enclosed, neither of which occurred in Sheriff's Meadow. The claimant, by the way, was kind enough to give some of the firewood that he cut down to the record owner, suggesting that the use may also have been permissive. In Seabaker, it was the record owner who invoked adverse possession for the purpose of extinguishing a 10-foot wide easement which ran across his property. The effort was successful based on a variety of activities which included parking, landscaping, and the installation of recreational facilities. Moreover, the fact that the holder of the easement had never made use of it and had failed to object to its obstruction was more than enough to demonstrate outright abandonment. Now, believe it or not, there's actually a vacant lot of land in South Boston. The guy living next door claimed adverse possession, but his use was not exclusive, given the fact that the record owner cut the grass, shoveled the snow, and stored lumber and other materials there. As a consolation prize, the claimant was allowed to preserve some minor encroachments. Now, as is our custom, we, for the most part, bypass those unpublished appeals court decisions designated by UP in the digest because they are not regarded as binding precedent. Once again, if any of them tickles your fancy, you can get copies from Lawyers Weekly. Just think twice before you cite any of them. But our first two official condominium cases both involve developers whose rights to expand a project by adding additional phases had expired. Now, in Glover Court, the developer, after the expiration, retained title to the expansion area. It was supposed to be his to do with as he chose, but that didn't stop the land court from requiring him to allow the unit owners to continue to park there. You see, there was no other space available within the perimeter of the condominium site, and the marketing materials had promised that off-street parking would be made available. This was essentially an easement by implication, much like the cases we've discussed in the past, where lots in an oceanside development were presumed to come with the right to also use the beach. In Graham, the excess land became part of the condominium regime when the developer's phasing rights expired. That being the case, a mortgage which the developer had placed on the expansion area automatically was extinguished and became null and void. In Wyman, the SJC upheld the decision, which we talked about 18 months ago. A condo association sued a developer for negligent construction and design. Now, negligent suits under the so-called economic loss theory normally require some evidence of personal injury or property damage rather than simply economic loss. But the SJC decided that the time had come to make new law. Given that there was no contractual warranty to enforce, the association would have no alternative remedy, and it would simply be unjust to prohibit a cause of action in tort. Our first easement case is Anerpet, where a commercial lot which had the benefit of an express easement was subdivided. The land court held, consistent with prior decisions, that all of the new lots could make use of the access way without impermissibly overburdening the easement. And that's, of course, because the area of the land to which the easement was appurtenant had not been increased. It had simply been broken up into smaller lots. Cabral is today's second example of how an easement can be deemed abandoned. The easement in this case was held by a developer, but when the time came to start construction, the local zoning board asked him to find a better means of access. He did so, and he told the board that the original easement would not be used to provide travel to and from the project site. He even placed 3 large boulders across the entrance to the easement area, and that was clearly enough to demonstrate his intention to give up that easement. However, he persuaded the land court that he had not relinquished the right to use the land below the access way for the purpose of installing underground utilities. An easement to enjoy an unobstructed view of Marblehead Harbor was lost by merger in Danforth when the dominant and servient estates became commonly owned in 1911. The easement was later recreated, but only on a temporary basis during the lifetime of the grantee. Now, the focus in Flynn was a driveway easement in the neighboring town of Swampscott. Absent any explicit reference to parking rights in the instrument which created the easement, the land court would not allow the holder to leave his car in the driveway because he had lots of room elsewhere on his own property, and it would be too hard for the record owner to get back and forth. In Nabham, the town of Sudbury obtained an easement back in 1903, allowing its residents to use a parcel of vacant land for access to the ocean. Now, fast forward to 2013, when the town and the owner of that parcel agreed to a relocation of the easement in order to facilitate a new residential subdivision. That would have been the end of the story, except that the Commonwealth intervened taking the position that this was a public easement which could not be modified without legislative approval. The land court disagreed, finding that the easement was meant to benefit only the inhabitants of Sudbury and not the public at large. Additionally, this was not the kind of conservation easement which could be moved only with the blessing of the legislature under Amendment Article 97 of the state constitution. In the United States, a house in Lincoln burned to the ground in 2005. Now, the owner decided to construct a 5-bedroom adult home to replace it, and he even obtained a special permit from the zoning board, only to discover that thanks to a series of conveyances by both private parties and the state legislature, his property was now surrounded on all 4 sides by the Hanscom Air Force Base with no right of access to a public street. Now, leaving aside whatever other recourse might be available, a U.S. District Court judge held that the owner could not install a new roadway without getting permission from the Air Force and complying with regulations issued by the National Park Service. So we all join in wishing him well. Moving on to eminent domain. The plaintiffs in Athersu commissioned a survey which purported to show that their land in West Hampton included a triangular portion of another piece of land which had been used by members of the public as a shortcut. Now, when the Board of Selectmen sent a very strongly worded letter contesting the plaintiff's title, they sought monetary damages for the alleged taking of their private property. As you might guess, a U.S. District Court judge could not find a single case in which a mere statement by a government official disputing somebody's ownership of land constituted a physical taking. In his view, holding the town liable for nothing more than correspondence over the status of a piece of land would discourage such communications from occurring in the first place and would also inhibit the amicable resolution of title disputes. Now, the property owner in Sorrenti Brothers did not do much better. You probably know who he is. He owns a gasoline station and convenience store right next to the Sagamore Bridge. You probably drive by cursing all the time. In any event, when the Rotary was eliminated a few years ago, it became more difficult for him and his customers to access routes 3 and 6 and the scenic highway. But the SJC held that this was not the equivalent of a compensable taking. In the words of Justice Botsford, although landowners have a legal right of access to the general system of public streets, they do not have a right to preserve a particular route in its original configuration. Now, the plaintiff in SDCO St. Martin, which you'll find under land use, constructed a commercial building which straddled the boundary line between Marlborough and Southborough. As part of the development process, he negotiated with Marlborough for a sewer connection. Southborough, you see, doesn't have a sewer service. Marlborough agreed to allow the connection subject to an additional levy above and beyond its customary hookup fee. In essence, the developer would have to make annual payments to the town of Marlborough calculated to approximate the extra real estate taxes which would have been payable to the town had the project in its entirety been located within the city limits of Marlborough. Now, when a subsequent owner complained, a U.S. district judge agreed that this was nothing more than an illegal charge which had no rhyme or reason or no basis in any kind of statutory authorization, and therefore it could no longer be enforced. The issue in Stone Ash was whether a seawall was located beyond the historic high water mark so as to be subject to the jurisdiction of the Department of Environmental Protection under Chapter 91. The appeals court held that it was appropriate for the department to base that determination on a map which had been prepared in 1819. Now, the owner protested that the plan was really nothing more than hearsay, but the court noted the impracticality of traveling back in time to cross-examine the surveyor. Residential tenants were very happy to learn of the decision handed down by the U.S. District Court in the Perry case. By statute, landlords are forbidden, prior to the commencement of any residential tenancy, from requiring a tenant or a prospective tenant to pay any amount in excess of the first month's rent, the last month's rent, a security deposit equal to 1 month's rent, and the cost of purchasing and installing a new lock and key. Equity Residential violated that law by requiring tenants to also pay a $50 application fee, a fee ranging as high as $500 for the right to use various amenities like a swimming pool, and a $250 fee for the privilege of being allowed to keep a pet. All of these charges should have been considered part of the cost of doing business, and they ought to have been factored into the basic monthly rent. Now, a different statute imposes strict liability, in other words, negligence isn't relevant, on the owners of certain types of buildings for injuries resulting from a violation of the state sanitary code. In Sheehan, the SJC held that the law has no applicability to residential premises. Accordingly, even though a tenant was hurt when he fell after leaning against a defective guardrail while climbing the stairs to his apartment, the landlord was free to raise the defense of contributory negligence, given the fact that the tenant had spent the previous 3 hours in a local bar room. In Von Papen, the plaintiff helped a pair of brothers acquire a 600-acre parcel in Wareham with the understanding that he would be given a 99-year lease on the cranberry bogs and sand quarry, which were included as part of that land. Now, the brothers took title to the property, but they never finalized the lease. They escaped liability primarily because the parties had not reached a meeting of the minds, let alone a written agreement, regarding all of the terms and conditions under which the lease would be subject. Refusing to hold those brothers accountable under Chapter 93A, U.S. District Court Judge Richard Stearns explained that it is not immoral, unethical, oppressive, unscrupulous, unfair, or deceptive, that's as far as he got with the thesaurus, to break off incomplete and imperfect negotiations. In his words, every deal that goes sour does not give rise to a Chapter 93A claim. Our mortgage cases continue to be dominated by foreclosure-related litigation, but I'm very happy to report that the number of decisions has plummeted dramatically from 41 back in May to only 22 today. Now, that may be a sign of improving economic conditions, but I'd also like to think that maybe the applicable legal principles have by now finally become so clear that there's nothing left to fight about. Borrowers desperate to keep their houses and other properties typically made the same tired arguments that we've been listening to for years and which have been rejected time and time again. As one judge colorfully put it, they tried to sell old wine in new bottles, but the courts didn't buy it or drink it for that matter. Once again, I beg your indulgence, hopefully for the last time, as we review these cases thematically rather than alphabetically, bouncing around up and down the list. Many of the cases will be mentioned more than once, given that borrowers and their lawyers tend to rely on lots of different arguments when they contest a foreclosure. Now, in Butler, Jenny, Schaefer, and Sheedy, state and federal judges, reiterated that a borrower does not have standing to complain that the enforcement and/or assignment of a mortgage somehow violated the provisions of a pooling and servicing agreement, or PSA, between various lenders and a trustee. Along the same lines, Bank of New York Mellon, Mitchell, and Schaefer all reminded us that a borrower cannot challenge the assignment of a mortgage on the ground that the officer who executed the instrument lacked authority. Chapter 183, Section 54B of the General Laws conclusively validates the assignment so long as the signatory purports to be acting as a designated officer of the assignor. Now, don't overlook that word designated. In Sullivan, an assignment, in fact, fell short because there was no recitation within the four corners of the instrument, or elsewhere in the record for that matter, of the specific title or corporate position held by the signatory. The appeals court bemoaned what it called the utter carelessness with which foreclosing lenders documented title to their assets. Now, that carelessness, of course, is also on display when lenders run afoul of the SJC's decision a few years ago in Ibanez, requiring that a foreclosing lender must actually be the holder of the mortgage on the date when the first notice of the auction is published. That didn't happen in Daucus, where the land court held that the power of sale had not been properly exercised. However, the mortgage did get assigned to the lender prior to the initiation of a different method of foreclosure, namely a physical entry followed by 3 years of peaceful possession. That was sufficient to extinguish the borrower's equity of redemption. Now, keep in mind that the assignment of a mortgage does not need to appear of record in order to be effective. Moreover, the courts have been more than a little loosey-goosey when it comes to the form of the document evidencing the assignment. In M&T Bank, for example, the assignment made no specific reference to the mortgage itself or to the address of the property, but it did list the account number of the loan, the interest rate, and the amount of the original financing. That, coupled with an affidavit and some other extrinsic evidence, was enough to satisfy the land court that the assignment, in fact, had taken place and was valid. In Mitchell and Schaefer, the same court also made clear that a mortgage assignment need not recite consideration. Now, even though the assignment of a mortgage, at least a residential mortgage, is supposed to contain the name and address of the mortgage broker and the loan originator, the omission of this data does not impair the validity of the assignment itself, thanks to the provisions of Chapter 183, Section 6D of the General Laws, which was applied in Mitchell. In Schaefer, which we've talked about before, there was no doubt that a trust was the holder of the mortgage at all times relevant to the foreclosure. The problem was the lack of any evidence that U.S. Bank was in fact the trustee of that trust. So for that reason, the land court refused to dismiss a complaint by the borrower seeking to nullify the auction. The borrower was also invited to pursue her contention that the trust was not the holder of the underlying promissory note as required by the SJC's 2012 decision in the Eaton case. I'm sure that by now you've all become painfully aware of how mortgage electronic registration systems functions. In essence, MERS holds legal title to mortgaged property in trust, while the note gets transferred among MERS's member institutions. In Mills, Jenny, Butler, Mitchell, Serra, and Sullivan, there was no doubt, both contractually and as a matter of common law, that this was an appropriate, legitimate way of doing business, and that MERS could eventually assign the mortgage to the current note holder in order to facilitate a foreclosure. Now, we've talked before about Chapter 244, Section 35A of the General Laws, which prescribes a detailed form of default notice which needs to be given to residential borrowers. Again, when I say detailed, it's an understatement, and it's very easy to leave stuff out or to say it the wrong way. If the notice fails to conform to the statute in any material respect, the borrower has the right to bring an equitable action seeking to enjoin the foreclosure. Now, on the other hand, if the borrower waits until after the foreclosure to question the notice, it's too late unless he or she can prove that the statutory violation, in the words of Chief Justice Gantz, somehow rendered the foreclosure fundamentally unfair, whatever that means. Those precepts were followed in Bank of New York Mellon, Jenny, Mitchell, and Schaefer. In none of those cases, by the way, was the court convinced that the foreclosure process, in fact, was fundamentally unfair, but 3 of the borrowers were nevertheless given leave to amend their complaints and introduce new allegations. Now, Section 35B of Chapter 244, which is the companion section, gives residential borrowers the right to cure a default before a foreclosure. It used to be that this right could be exercised once every 5 years, but the legislature got more generous in 2010 when it gave residential borrowers the right to cure a default under the statute once every 3 years. In Stokes, however, a U.S. District Court judge held that that 2010 amendment could not be applied retroactively to a borrower who had already received his first chance to stave off a foreclosure. Now, a related issue in Jenny was the fact that the bank's default notice may not have conformed to the provisions not of the statute, but of the mortgage itself. However, because this was a contractual rather than a statutory defect, the land court held that it could not be raised against a third party who had acquired the property at a foreclosure sale in good faith without any knowledge of that problem whatsoever. A borrower's financial inability to cure a default will typically result in a plea that the terms of the loan be modified. In general, as we saw in Cabrera, banks have no legal obligation to oblige. Nonetheless, Chapter 93A may come into play in particularly egregious circumstances. For example, get this, the lender in Charest required documentation and other information which it already possessed. It miscalculated the borrower's income. It repeatedly misrepresented her eligibility for a loan modification under a federal program, and it denied her repeated applications based on incorrect facts. Similar transgressions occurred in Stokes and Johnson, where the lender concealed the fact that a loan modification would require the consent of an investor, and to make things even worse, he made no effort to obtain that consent. The borrower also accused the lender in Johnson of a simple breach of contract for having repudiated a commitment to grant a permanent loan modification if the borrower complied with the terms and conditions of a trial period plan. Now, on occasion, a borrower will attempt to rescind a mortgage on the ground that disclosures required under the Truth in Lending Act were not made at the time of closing. Any such rescission must, under the statute, take place no more than 4 years after the closing of the mortgage. And the SJC held in the May case that once that statutory period has expired, no additional right of rescission is available under common law. JEFRA, which we discussed 6 months ago, has now been affirmed by the U.S. Court of Appeals. The case has already become an anachronism because what I'm going to describe to you has subsequently been prohibited pursuant to regulations adopted by the Attorney General. The case involved the so-called foreclosure rescue transaction, where a borrower paid somebody to buy his house at a foreclosure sale and then to let the borrower stay there in exchange for rent payments. Well, it turned out that the rent was even higher than the previous principal and interest payments, which the borrower hadn't been able to afford, and the rescuer himself eventually defaulted on the loan which he had taken out in order to acquire the property on the borrower's behalf. But nevertheless, the court said that the foreclosing lender was not in pari delictu with the rescuer, knew nothing about this scheme, and therefore the foreclosure could not be challenged. A lender's failure to comply with the procedural requirements of the Service Member Civil Relief Act has no bearing on the validity of a subsequent foreclosure, as the land court reiterated in Mitchell. There was no suggestion that the borrower had actually been a member of the armed forces. A dragnet clause was construed in Natali, where a mortgage secured all, direct or indirect, absolute or contingent, past, present, or future obligations of an individual buyer. As you might imagine, that was more than enough verbiage to make the property collateral for a guarantee, which was subsequently granted by the borrower for the benefit of a limited liability company. We conclude with two garden variety reformation cases. In Citibank, a husband was required under the terms of a divorce decree to convey a house to his wife. The lender assumed that he had done just that and accepted a mortgage in the name of the wife alone. When it was later discovered that the conveyance had not yet occurred, the contrite husband was forced to add his name to the mortgage. In Dawkins, meanwhile, a mortgage was reformed to correct the spelling of the borrower's name in order to clear title for the benefit of the current owner who had acquired title via foreclosure. Today's first published case on purchase contracts is KGM, where a developer had entered into an agreement to purchase 45 acres of land in Norton for a residential subdivision. Sometime prior to the scheduled closing, the seller announced that he had no interest of going forward. Now, that's what we call an anticipatory repudiation. And the only recognized remedy for it in Massachusetts is a suit for specific performance. While such a suit was pending, the seller agreed to schedule a closing and to see whether things could work out. But in reality, it was nothing more than a charade. The seller insisted, for example, on getting his hands on the buyer's check before letting the buyer and his lawyer take a look at the deed and the other closing documents. I mean, I kid you not. The lawyer actually was at one end of the table and said, here's the deed, is it okay? In any event, what this meant is that what had been an anticipatory repudiation now became a very, very simple breach of contract, because the buyer said, hey, this is ridiculous. He walked out. He refused to close. And on that basis, the SJC held that the seller's shenanigans at the closing entitled the buyer, if he so elected, to forego specific performance and instead collect damages for breach of contract. In Savory, an accountant who was known to be in dire financial straits because of some sour investments held a right of first refusal to acquire an abutting lot. The owner of that lot preferred to sell it to a developer. So the two of them got together, and they decided that the best way to thwart the right of first refusal was for the developer to make an offer which the accountant would not be able to match, namely a quick, all-cash sale with no financing or other contingencies. The accountant protested when he received a copy of the notice inviting him to match the offer. He said that this was illegal collusion, but the land court disagreed. Even if motivated by a desire to defeat a right of first refusal, a third-party offer is still considered bona fide in the absence of out-and-out fraud. In other words, there was nothing wrong with the owner and the third party simply concocting a way in which the accountant would not be able to take the property away from the developer. By the way, that accountant might not have been able to buy that lot, but he did get his revenge when the developer applied for a building permit, as you'll see when we revisit this case in the zoning section. Now, in Urban, a purchase and sale agreement contained a familiar provision that the acceptance of a deed precluded the buyer from asserting any subsequent claims under the contract. In other words, the contract merged with the deed, and the only claims you could raise would be based on the quitclaim covenants or something like that. A U.S. District Court judge explained, however, that the buyer was still free to pursue the equivalent of a tort suit based on the seller's violation of the implied covenant of good faith and fair dealing. The seller in this instance happened to be Freddie Mac, which had signed a contract, a purchase agreement, in which it promised to provide free title insurance to the buyer so long as the buyer obtained the policy through Freddie Mac's attorney. Now, when the buyer tried to take advantage of that offer, Freddie Mac's attorney refused to issue the policy on the ground that he would then be deemed to have illegally represented both parties to the same transaction. The judge held that Freddie Mac could be held accountable for knowingly making a promise that it simply could not keep. Our first subdivision case is captioned Georgetown Planning Board versus Georgetown Planning Board, which I'm sure has some of you scratching your heads. An approval not required A&R subdivision plan was deemed to have been constructively approved when the board did not take action within the prescribed statutory 21-day period. Now, when that happens, a constructive endorsement can be appealed by a demonstrably aggrieved third party, for example, an abutter. But the land court held that the board itself had no right to seek judicial relief from the consequences of its own negligence. By the way, they tried to throw in the local building inspector to preserve standing, but the court held that he wasn't of any use either. Only a private party can complain when public officials don't live up to their public obligation. A developer in Naaman sold the subdivision lot to a buyer who proceeded to construct a new house. During the course of the work, the buyer infringed on some adjoining conservation land which was held in the name of a trust. When the developer brought suit, the land court held that only the trust had standing to complain. Now, the developer was able to seek the enforcement of a restriction which he had placed in the deed, and that restriction prohibited the disturbance of a particular portion of the lot where the buyer had gone ahead and planted trees and other vegetation. But the court refused to grant equitable relief in view of what it called the lush and vigorous plant life which the buyer had improperly created. Samuelson involved some property in Orleans, which had been subdivided in 1975, subject to a condition under which the planning board prohibited the creation of any additional lots until an existing roadway had been brought up to snuff and conformed to the planning board's construction standards. 35 years later, the board agreed to allow 2 more lots, but the land court held that it had put the proverbial cart before the horse. It would first be necessary to either eliminate that restriction from the 1975 decision or to grant a waiver allowing the developer to deviate from the board's regulations. Now, in Seac, the Ludlow Planning Board approved a subdivision plan showing the extension of an existing road. 5 years later, the board endorsed an A&R plan which combined 2 of the lots and eliminated the extension. After finding out what had happened, an abutter lodged a protest. Now, both the developer and the planning board argued that he was too late because he had not challenged the approval of the A&R plan. But the land court saw things very differently. In its view, the purpose of the subdivision control law would be subverted if an approved subdivision plan could be altered by the simple expedient of procuring an A&R endorsement. Like we just saw in Samuelson, the developer would have to go through the hoops and seek a formal modification of the original subdivision plan. In Taylor, an A&R plan was endorsed after the Lester Planning Board found that the proposed new lots had sufficient frontage along an existing road which would provide adequate access for emergency vehicles and other traffic. The only problem was that there was no evidence in the record to support the board's determination. The town engineer, on the other hand, had testified that in his professional opinion, the road was subject to erosion, it was impassable by passenger vehicles in several areas, and it was too narrow to accommodate more than one direction of traffic at a time. And because no one had effectively rebutted that testimony, the ANR endorsement should have been denied. In Go Duty, which is indexed under taxes and tax takings, a private lender was attempting to foreclose a mortgage by entry. Now, before the necessary 3 years had run, he accepted interest payments from the borrower. And I didn't realize this, but now we all should. That effectively amounted to a waiver of the foreclosure, according to a 1931 decision by the SJC. That being the case, the town was well within its rights to assess real estate taxes against the borrower, and that entitled the city of Worcester to proceed with a tax taking for non-payment. You shouldn't be surprised by the decision of the U.S. Court of Appeals in Johnston, where Freddie Mac and Fannie Mae were both granted immunity under federal law from any obligation to pay the stamp tax, which is otherwise applicable to the sale of real estate in Massachusetts. The title section is where we find the customary potpourri of disputes between siblings and other relatives who don't get along. In Allen, the appeals court affirmed an earlier decision by Judge Piper. A mother signed a deed conveying her house to her son. The son then arranges to have the deed notarized by someone who would never even met the mother, let alone taken her acknowledgement. Now, even though that deed was recorded, and even though on the face of it, it looked perfectly legitimate, it nevertheless was considered a nullity, and it did not impart constructive notice, meaning that the mother was now free to convey the very same house to her daughter. In Chiarelli, a house in Quincy was owned jointly by two sisters. One lived there with her husband, while the other one had moved to Florida. Now, the Florida sister transferred her share so that the Quincy sister could arrange a mortgage loan, supposedly to fund necessary repairs. Now, the Quincy sister had promised to reconvey the joint interest immediately following the closing, but she later refused to do so. Now, the agreement between those sisters was not in writing, but even though the statute of frauds normally bars the enforcement of an oral agreement related to the conveyance of real estate, this case was governed by an exception protecting a party who has already lived up to her end of the bargain. The Florida sister was entitled to recapture her ownership interest, and she graciously agreed to let the mortgage stay in place, even though most of the proceeds had been used not to make repairs, but rather to consolidate debts which were owned by the Quincy sister and her husband. Morris was a fairly unsettling decision, at least in my view, focusing on a nominee trust which contained the usual provision which we've used time and time and time again, that the execution of a deed by the trustee was conclusive evidence that the deed had been duly authorized by the beneficiaries. The land court held that that clause was meant to protect only a bona fide purchaser for value. The grantee in this case happened to be the grantor's daughter, who paid only $100 for a house in Dorchester which was worth nearly $80,000. Because the conveyance had not in fact been authorized by other family members who were the beneficiaries of the nominee trust, the deed was considered invalid. Apfel was another land court decision which was affirmed on appeal. A declaration of protective covenants prohibited the further subdivision of a parcel of land. When those covenants expired and were later amended, restated, and extended for another 20 years, the ban was lifted and the developer could proceed. I think, by the way, there's a typo in the digest. I think the word expired was left out at the end of that, the description of that case. I learned in law school, in tort class, that it would be nearly impossible to manufacture a can of tomato soup which didn't have at least some trace of a worm in it. And I'm now convinced that it's equally impossible to ever produce one of these digests without at least one typo, but I take the blame for that. Bassin is a very useful decision on the subject of trees. Judge Sands taught us that you always have the right to cut branches and roots which extend onto your property from a neighbor's yard. But if the trunk happens to straddle the boundary line, you cannot kill the tree unless it happens to be diseased. Now, along the same lines, no legal liability results from the blowing or dropping of leaves, branches, and sap from a healthy tree. Simply something that's expected, especially with the kind of weather we had yesterday. But if the tree is diseased, which means that there's likely to be a lot more falling and damage, the tree becomes a nuisance and it really ought to be removed. The first American decision involved a lender's policy which was issued to a Washington, D.C. law firm which had obtained a mortgage from a client in order to secure the payment of its legal fees. Now, because of what was described by the U.S. Court of Appeals as a clerical error, the policy failed to mention an existing mortgage. But be that as it may, the standard exceptions excluded from coverage any lien or other defect which had been agreed to by the insured claimant. And because the law firm had clearly known all along about the prior mortgage, any recovery from the title company would be an unjustified windfall. In Hulton, and I hasten to add that that is spelled Hultin, a debtor by that name sold some property which he owned in Boston. Now, when the deed was recorded, the Suffolk Registry erroneously entered the conveyance in the grantor index under the name Hilton, Hiltin, transposing the I for the U. After the seller went belly up 10 years later, the trustee in bankruptcy, who legally has all the rights of a good faith purchaser without notice, tried to invalidate the sale and recapture title to the property. But the bankruptcy court, God bless them, refused to go along. Under Massachusetts law, which was applied in that case, an indexing mistake does not render a recording ineffective. The loss falls on the subsequent purchaser, or in this case, the trustee. As part of the comprehensive 2010 statutory amendments, the holder of a beneficial interest in a trust was allowed for the first time to declare a homestead. In Newcomb and Van Buskirk, residential property was held in the name of a trust whose beneficiary happened to be a different trust. Now, mindful of the public policy in favor of liberally construing the statute, the bankruptcy court held that the beneficiary of the downstream trust, i.e. the beneficiary of the beneficiary, could legitimately claim homestead protection. Two of today's cases concern attachments. In Raymond, a debtor cited a statute for the proposition that the obligation evidenced by an attachment is deemed to have been satisfied after 20 years. The debtor's attorney was promptly and correctly warned by the lender's counsel that he had misread the statute and that it created nothing more than a presumption of payment and that the obligation undisputedly remained outstanding. Because the debtor's counsel stubbornly and unsuccessfully persisted with the litigation all the way through summary judgment, he was sanctioned and required to pay the lender's legal fees and other costs. In Rivera, meanwhile, the debtor forfeited his statutory right of redemption when he failed to tender the full amount due within 1 year after a sheriff's sale. In Rocco, the land court upheld an agreement among co-tenants that they would not seek to partition the property in question so long as any of them was still alive. Now, when it was argued that the agreement was an unreasonable restraint on alienation, the land court disagreed, noting that the youngest of the co-tenants was already 60 years old, which would naturally limit the duration of the restriction because of his relatively short life expectancy. So thank you very much for that, Judge. It's now time to take another look at the Savary decision, which reappears in today's index under zoning exemptions. Now, when zoning first came to Nantucket, which wasn't, by the way, until July 27th, 1972, a minimum lot size of 50,000 square feet was established in order to build a single-family house in a particular part of town. Now, Chapter 40A, Section 6, provides an exemption for smaller lots so long as they were not held in common ownership with any of the adjoining parcels at the time when the zoning code first took effect. In this particular instance, a husband and wife had checkerboarded their lots just days before the code was adopted, putting one in the name of the husband and the other in the name of the wife. The land court rejected the suggestion that this had been done for bona fide estate planning purposes, and get this, to respect the autonomy of the wife, who was described as a remarkable woman of intelligence, independence, and self-direction. This was in reality nothing more than a case in which a highly educated couple with financial resources, business savvy, and access to legal counsel were intent on gaming the system in order to preserve the value of their land. To all intents and purposes, the lots remained under common control and the exemption was unavailable. Now, I would have been willing to bet serious money that the appeals court was going to overturn two land court decisions on non-conforming uses, which we discussed a year ago. In a crushing blow to my self-esteem, both decisions were upheld. By the way, they're going to be discussed in a lot more detail at the forthcoming Abstract Club meeting. Now, the basic rule of thumb used to be that a non-conforming single-family house could be enlarged or otherwise modified under Chapter 40A so long as the existing nonconformity was not made any worse, or if it was, so long as the reconfigured house would not be substantially more detrimental to the neighborhood. In what the court graciously referred to as a case of first impression, which I guess made me feel a little better, an additional prerequisite was added in Dedrick, namely that no new nonconformity can be introduced. In this particular instance, the proposed enlargement would, for the very first time, cause the height of the house to exceed the limit imposed by the local zoning code. The court held that, therefore, the house could not be reconstructed without a variance. Then there was Welsh Filipino, involving a Newburyport a Newburyport nursing home, which had previously been built on land which was now zoned to allow only single-family houses. Now, plans were made to expand the facility by not only increasing the number of beds from 100 to 123, but also by demolishing the existing building and constructing a new one, which would more than double the footprint from 12,686 square feet to 28,780, emphasizing the fact that the building itself would conform to the dimensional requirements of the local zoning code. The court decided that this was neither a change nor a substantial extension of an existing non-conforming use, and therefore could proceed without the necessity of a trip to the appeals board. Many of the cases in the next section of the digest deal with the issue of whether or not a developer was entitled to a special permit under the particular provisions of a local zoning code. Now, most of those cases are fairly mundane and can be safely passed over, but there is one that deserves your attention, namely Doherty, not only because it was handed down by the SJC, but also because it establishes a fairly significant principle of interpretation. Back in 1972, the town of Scituate adopted a zoning code amendment allowing the issuance of a special permit for the construction of residential dwellings in an overlay district, but only if the site was not subject to flooding. Now, back in those days, 42 years ago, the likelihood of flooding was normally addressed by reference to the elevation of a parcel above sea level. And on that basis, the appeals court had held that it was appropriate for the special permit to have been granted. In other words, you interpret a zoning code based on the facts and circumstances which existed at the time when the code went into effect, which is the whole notion behind original construction, which Justice Scalia is very fond of on the U.S. Supreme Court. But be that as it may, the SJC reversed, and they decided that it was altogether appropriate for the zoning board to consider the current science and technology of flooding as reflected in FEMA flood zone data, which post-dated the adoption of the 1972 amendment. The property was included in no fewer than 3 different FEMA flood zones. And moreover, there was testimony from abutters that the parcel had been flooded on various occasions. All in all, the board was well within its rights to deny the special permit. Somebody aggrieved by the rejection of a special permit application typically has 20 days to file an appeal. But when that someone is Bell Atlantic Mobile, and when the issue is whether or not the denial of the special permit will inhibit cellular telephone service coverage, the appeal can be filed in federal court pursuant to the Federal Telecommunications Act of 1996. That law affords a 30-day appeal period, and the court held that that period preempts the 20-day period, which appears in Chapter 48. Now, in those run-of-the-mill cases where the 20-day period does apply, the plaintiff needs to make sure that the town clerk knows about the appeal before that deadline passes. The easiest way to do that, of course, is to file a copy in the clerk's office. There have occasionally been cases in which the courts have interpreted the statute a bit loosely. For example, by letting the plaintiff deliver a copy of the complaint to the clerk at his home on the evening of the 20th day after the clerk's office had closed. But in Sweeney, a copy of the complaint was faxed to the clerk's office after business hours on the 20th day. How quaint. And it wasn't seen by the clerk until the morning of the 21st day, making the appeal untimely. In Daniel, a speculator purchased a vacant foreclosed upon lot in Marshfield for $27,000, which happened to be about 1/6 of its assessed value. He then applied for a variance to allow the construction of a single-family house, but it turned out that a similar application had been filed by somebody else and had been rejected during the past 2 years. As a result, the zoning board lacked jurisdiction under Section 16 of Chapter 40A, which prohibits any application from being favorably acted upon within 2 years after a previous unfavorable decision, unless there have been specific and material changes in circumstances, which was not the case here. The Franklin Zoning Code gives the planning board the right to issue a special permit authorizing the construction of a senior housing project. In Eastern Management, the developer didn't like the fact that the board had limited the number of units which could be built. So what did he do? He sought a variance from the local zoning board of appeals. Now, the land court held that even though Chapter 40A authorizes variances from the provisions of a local zoning code, the ZBA was not empowered to vary the terms and conditions of a special permit which had been issued by a different agency of the town. The developer should have sued the planning board when he had the chance. The reconsideration and reversal of a decision denying a special permit normally requires notice to abutters as well as a new hearing. What made Lingerman different was the fact that the original decision had not yet been filed with the town clerk. Accordingly, the appeals board was free on its own initiative to change its mind and to grant a special permit allowing the manager of a horse farm to live in an on-site apartment. In Leiden, a judge had issued a decision to the effect that a variance allowing the operation of a landscaping business was invalid. The appeals court has now joined the land court in construing that decision as the equivalent of an injunction prohibiting the illegal use, because the operator had stayed in business, erroneously believing that the original decision was stayed pending an appeal. He could be held in civil contempt. In Plotka, a Swampscott dentist whose office I pass by on the way to and from work every day needed a variance for a sign which would be 7 times larger than what's allowed by the local zoning code. And they think lawyers have big egos, by the way. He contended that because the building was located on a peninsula jutting into the ocean, the shape and topography of the lot entitled him to special dispensation. The land court predictably disagreed in the absence of any demonstrated hardship. The first official Massachusetts miscellaneous zoning case on the agenda is Bourne, where a project was built pursuant to a provision of the Sudbury zoning code allowing independent, and that's going to be the key word, independent living facilities for persons 55 years of age and older. Now, one of the residents complained that he was not receiving therapy, transportation, or housekeeping services. To add insult to injury, the indoor swimming pool had been drained and padlocked. Now, the land court instructed the local zoning board to establish criteria designed to make sure that the occupants of the facility would be able to remain independent, that's again the key word, for as long as possible. It was not enough to simply defer to the managers of the facility to decide what was best for all these old fogies over 55. At a bare minimum, it was suggested by the court that there would need to be a 24-hour staff, meals available on request, exercise facilities, and activity rooms where residents could socialize and interact with each other. In Bylinski, an abutter brought an action in the nature of mandamus, seeking a judgment which would compel the local building commissioner to order the removal of a house which had been built on an undersized lot in the town of Douglas. Now, mandamus, as you probably know, is considered an extraordinary equitable remedy which can be invoked only if an aggrieved party has no other recourse. And that was not the case here. As the land court pointed out, what the abutter could have done and should have done was to simply request the building commissioner to enforce the code. And if she refused, the next step would be an appeal to the ZBA, followed, if necessary, by an action seeking judicial review. Thanks to a decision by the SJC 15 years ago, the normal rule is that anyone who objects to the granting of site plan approval for a particular project cannot file an appeal unless and until a building permit is subsequently issued. However, local cities and towns have the right, on their own initiative, to put into their zoning codes a provision which does allow site plan approval decisions to be appealed directly to a court, and we have no fewer than 4 cases on today's docket where that's what happened. In Cocobella and M&K Partners, the land court simply decided that it had subject matter jurisdiction without reaching the merits of the case. In Dachi, the court went further, holding that site plan approval had been properly granted so as to allow the construction of a new bituminous concrete plant in Rochester. As the Chief Justice explained, site plan approval for a use which is otherwise allowed as of right can be denied only if there is no reasonable solution to an intractable problem. In this instance, concerns regarding noise could be addressed effectively by simply requiring that the plant be operated in conformity with regulations of the State Department of Environmental Protection. In Prestige Car Wash, the court decided that the operator of an existing gas station and convenience store lacked standing to challenge site plan approval, allowing Cumberland Farms to open a similar establishment down the street. In the words of the decision, the primary purpose of zoning is supposed to be the preservation in the public interest of certain neighborhoods against uses which might be deleterious to those neighborhoods. On the other hand, zoning regulations do not exist to shield businesses from honest competition. As we saw in Bylinski, when somebody wants to challenge a project which is allegedly being built in violation of a zoning code, it is normally possible to ask the building inspector to take appropriate action. And typically you can wait, for 6 years to do that, subject to laches. That avenue is unavailable, however, where the opponent knew or should have known that a building permit was issued and failed to file an appeal with the ZBA within the 30-day period prescribed by Chapter 40A. Now, in Gavin, the land court held that active opponents of a proposed wind turbine project in Kingston had imposed on themselves an obligation to find out whether or not a building permit had been issued, at which point it was incumbent on them to initiate a timely administrative appeal. They could not wait for the 30 days to pass and then go complain to the building inspector. Finally, one Ledgemont arose in the context of a zoning case, but was primarily an evidentiary decision by the land court. During the course of preparing for trial, an abutter sought discovery of emails and other correspondence between the developer's attorney and its real estate consultant. Now, because the consultant was not technically an employee of the developer, the abutter argued that the attorney-client privilege did not apply. But the court disagreed, noting that the consultant had a long, close, and pivotal role to play in all of the client's business transactions and had essentially morphed into the functional equivalent of an employee. So let's all pledge to stay true blue and not morph into the inspiration of Hank Philippi Ryan's next book. I'll see you all in May. Take care.